just before you go, can I just say formally, in case anyone is here to whom it affects, there was a case listed for hand down. That was an accident. It has in fact been handed down remotely, so I don't think any of you are probably here to listen to that anyway, but I've asked for it not to be called on because it's not formally being handed down. Right.
Appeal in the matter of the Queen on the application of Salvato and the Secretary of State for Work and Pensions.
My Lord, my Lady, I appear on behalf of the Secretary of State for Work and Pensions in this matter with Miss Ruth Kennedy, Mr. Chris Butler, Queen's Counsel, and Miss Jones appear on behalf of the Respondent. My Lords, my Lady, I was going to begin, if I may, with the statutory scheme for the payment of childcare costs within universal credit.
Oh, I'm so sorry, it's just for my note. We've got leaders but not juniors on the slip, but it's the same juniors as on the certain arguments, presumably.
It is, yes.
Thank you. Sorry, you go on.
My Lords, my Lady, you have the statutory scheme at tab 1 of the authorities bundle. You may wish to have that to hand.
Yes.
Section 1.
So, hang on 1 second.
So, 2 authorities bundles.
Yes, tiresomely, only a minor point. Let me get it off my chest. They aren't marked as to which is which. But yeah, okay. I will do that now.
I think that we can start at tab 3.
Yep.
My Lord, Section 1 of that Act instituted the benefit known as universal credit. Section 7 of that Act enshrined that universal credit would be payable in respect of an assessment period. The Act specified the fundamental elements of what would be paid under universal credit. Section 9 allowed for a standard allowance. Section 10 provided for an amount which would be paid where a recipient had responsibility for a child. Section 11 made provision for the payment of housing costs and specified that those could be paid in respect of a liability. And Section 12 was a catch-all provision that provided that the calculation of an award of universal credit would include amounts in respect of particular needs or circumstances of a claimant. Of course, the detail of how the Act and the aims of universal credit were going to be realised were set out in the regulations which followed, the 2 sets of regulations. The defining feature of universal credit, as is well known, is that it's paid in arrears. It's intended conceptually to mirror the way in which the vast majority of the population is paid their salary. And that was given statutory effect by Regulation 47 of the Universal Credit Personal Independence Payment, Job Seekers Allowance and Employment and Support Allowance Regulations. And my Lords, my Lady, you have that at tab 5. And Regulation 47.1 provides that universal credit is payable monthly in arrears in respect of each assessment period, unless in any class or classification.
Just 1 moment.
I'm so sorry. So, my Lord, it follows that universal credit is always paid in arrears, and as we'll see, although housing may be paid on the basis of a liability, it is nonetheless paid in arrears. And of course, I'll return in the course of this argument to the fundamental differences between the payment of housing and childcare. My Lords, my Lady, universal credit flexes according to circumstance. It is paid both to those who are out of work and those who are in work. In this case, and indeed it's part of the respondent's complaint, is that when she elected to reduce her hours of work, so her universal credit payment went up to cushion her drop in income. And as we'll see, one of the aims of universal credit was that it was to meet the needs of those people who worked flexibly and whose hours of work were not set from week to week or month to month. As you'll have seen as regards the respondent in this case, when she began work, she was paid £31,000 per annum. She reduced her hours, although as she said in her second statement, she's gone on to also take up some ad hoc work as a columnist for the Sun newspaper. It's an example of someone who has also taken on a more flexible form of work alongside more regular hours. The respondent's assessment period within universal credit ran from the 7th of the 6th to each month, per the statutory scheme, and again, this is within Regulation 47 that we've looked at. She was paid within 7 days of that, and then, in her case, she was paid her salary on the 20th day of each month as well. My lords, if I can then turn to Regulation 33(1) ZA, which specifically provides for childcare. My lords, my lady, I think that you now have this in a separate bundle, and I think, in fact, you may have had it twice over, possibly.
Just tell us where it should be. I did receive something electronically yesterday, which I'm afraid I didn't print, so I assumed we'd be given a hard copy.
Can I hand up a hard copy if you don't?
Yes, that's what we need now, is it? Yeah.
Yes, we should have both. They're coming.
Thank you.
Thank you very much. My lords, my lady, I think that the provision that you need is on page 73 of that large bundle.
This can't fit into our existing bundle, I suppose. It wouldn't fit anyway. No, you can't afford a folder to put them in.
I thought that they had been provided to you in
Well,
hard copy.
Oh, I see. Well, maybe they have. But if so, I'm not conscious of having received them, is all I can say.
I thought that
No, don't worry. Things often take a bit of time to reach.
we can get some files in any event over lunch.
I can do that over lunch, don't worry. I was just teasing you. So page 73.
Yes, that should take you to Regulation 33. Do you have that?
Yes.
My lords, my lady, you'll see from that what it provides for. So we see it.
So just to help me, I should be on top of this, but I'm afraid I've only looked at these things as they appear in the skeletons and the judgment. Why is this different from what we've got in the main authorities bundle?
Because in the main authorities bundle, you had the regulations as they were originally enacted.
Oh, I see.
And this is the amended version.
This was the version in
and
force.
It's the amended version. It's the version in force, and it's
Okay,
the
that
version.
explains it. Thank you. I just hadn't taken that in. Yep.
So just turning then to Regulation 31, Regulation 33(1, you'll see that the childcare costs condition is met in respect of an assessment period if the claimant has paid charges for relevant childcare that are attributable to that assessment period, and those charges have been reported to the Secretary of State. And then one sees that the charges are in respect of a child, that's at A, for whom the claimant is responsible, and B, the charges are for childcare arrangements, and 2 makes provision for the late reporting, which we don't need to concern ourselves with here. And then over the page at Regulation 34, it provides that the amount of the childcare cost element for the assessment period is the lesser of 85% of the charges paid for relevant childcare that are attributable to the assessment period, or the maximum amount set out in Regulation 36. I'll take you to that. But then at Regulation 34A, again, it provides more detail as regards how childcare charges are to be attributed to an assessment period. So charges paid for relevant childcare are attributable to an assessment period where those charges are paid in that assessment period for relevant childcare in respect of that assessment period, or those charges are paid in that assessment period for relevant childcare in respect of a previous assessment period, or those charges were paid in either of the two previous assessment periods for relevant childcare. So Regulation 34A provides a little bit of flexibility for childcare to be paid and then attributed to assessment periods that follow. And you'll see that a formula is set out as to how that is to be calculated. And then Regulation 36 sets out the amount that can ultimately be awarded. And that's the last cost set out in the table. So £646 for one child, or £1,108 for two or more children. My Lord, the effect of this rule is what is described in these proceedings as the proof of payment rule, that in order to recoup or be reimbursed payment for childcare as part of universal credit paid in arrears, you must demonstrate to the Secretary of State what you have in fact paid for childcare. The effect of this is described in the witness statement of Neve Parker on behalf of the Secretary of State. And for your note, her statement is at B2 603. But I can set that out briefly.
We're going, and I don't blame you for this, because this is obviously what the case is about, but we're going quite carefully through the regs. But I'm right in thinking, aren't I didn't detect there was any disagreement with the very clear way in which Mr. Justice Chamberlain summarised all these, the relevant provisions in the first, whatever it is, paragraphs of his judgment.
Yes.
Yeah, okay.
I don't think that there is any dispute, my Lord. I think the point on behalf of the Secretary of State is to emphasise the importance of the entire scheme being paid on the basis.
That I understand entirely, but just in terms of looking at detail and, you know, which rate does what and so on, it's all very clearly set out there. Yeah, okay, thank you.
My Lord, just picking up then the overall description of this, set out at paragraph 22 in the witness statement of Neve Parker, where she says the whole policy, and this is in respect of universal
Which paragraph did you say?
It's paragraph 22.
Yeah.
Has been developed with the monthly assessment period at the heart, with payment in arrears, meaning that any change in the core design principle would have very significant impact and associated cost. And I'll come back to that point in due course.
Well,
and she
surely there's no challenge here, is there, on the concept of payment in arrears?
No, my Lord.
So what? Right. It's in arrears of what? Is it in arrears? It's essentially, is this the issue? It's whether it's be paid, as it were, in arrears of an invoice or in arrears of a receipt.
Yes, but my Lord, it's not as straightforward as that.
Well, I'm sure it isn't, but I'm just worried. Well, not worried, but I want to make sure I've understood correctly. There's a great emphasis on payment in arrears, as if this was a challenge to the principle of payment in arrears. But as I understand it, it isn't. Have I got that wrong?
Well, the issue, and I think the way that it crystallised in the judgment, was because Mr. Justice Chamberlain placed so much emphasis on the idea that you could pay on the basis of an invoice. And the point on behalf of the Secretary of State is, even if you were paying on the basis of an invoice or a liability, you nonetheless still have the problem, it's the same with housing, or not the problem, it's the key feature of the statutory scheme, that nonetheless it is still paid in arrears. So even if an invoice was raised on the first day of an assessment period, it still wouldn't be paid until after that assessment period has ended. Those costs have been factored into the universal credit, the taper applied, and the final amount of universal credit arrived at, contingent on whatever has been earned in that period. So that's why the fundamentality of payment being in arrears matters in this case.
Well,
and that
at the moment I still don't quite see that, but you've got plenty of time to explain why this really is about payment being in arrears, whereas it seems to me to be about something slightly different.
Okay. Well, my lord, if I can just pick up where I was.
Yes.
My lord, again, it's just at paragraph 53. Again, Miss Parker is describing universal credit paid monthly in arrears. Entitlement is decided at the end of each assessment period. With regard to childcare costs specifically, attempting to extract or ring-fence individual components from the calculation would ignore the interaction between the different stages of the calculation and would not reflect correctly how universal credit is designed in the legislation.
But that's again not, sorry, I'll try and keep quiet. It's not quite what has been suggested should happen, is it? Isn't she a challenging an Aunt Sally? Or perhaps it wasn't an Aunt Sally when the case was first of all brought, but by the time it's matured, the hearing, it seems to be about something slightly different from the issue that she's emphasising.
Yes, and my lord, I'm going to come to how
Fair
the
enough.
case develops
Fair
as
enough.
well, because I do think that that's important also, so that you understand that and can put it in context and can see why the evidence was put in that way.
Yes.
But nonetheless, I hope that I've demonstrated to you, and as you've observed, it doesn't really seem to be in any doubt, that the concept of payment in arrears is the key defining concept of universal credit. My lord, in terms of how that works in practice, and looking at the simplicity of the system as well, we can actually pick that up from looking at some of the universal credit statements that were in evidence in this case. And a useful place to look at that might be in Supplementary Bundle 2 at page 504.
Again, unhelpfully, nobody's actually said what Supplementary Bundle 2 is. Right, I have two copies of something called Supplementary Bundle, which
There's actually a tag on the front of mine.
my ladies. Oh, I see. Sorry, someone has put it in. So part 2 you want?
Yes, my lord. In fact, if you pick it up at page 5,
Just wait one moment. Just right at the back.
this might be the easiest way to look at it in opposition. So, my lord, this is a statement of one of the witnesses.
Which page did you say?
Page 500.
Thank you.
Oh, I thought you were looking at 504.
Sorry, I am going to. I was just introducing this set of statements. So, as regards this witness, in the first month that is exhibited, there isn't a universal credit payment. And you can see that because her pay, which is set out over the page, which was in excess of £2,500, meant that she wasn't entitled to a universal credit payment. I think that's probably because on her evidence she was still being paid from her previous employment. And if we go on to look at each of her statements, one can see the simplicity of it. So if one looks at page 505, under universal credit, what she has been paid is known. So it sets out what her take-home pay is. It then sets out each.
So sorry, page 505 is this?
Yes.
A505.
So 504 is page 504 is the statement
Yes, I see.
for an assessment period, the 24th of January to the 23rd of February. So if you look at page 505, the system knows what she's been paid for that in that assessment period. It factors that in to the ultimate assessment made of what she's entitled to. So as regards this particular witness, she was entitled to the standard amount, she was entitled to housing, support for a child, and her childcare, so the £646 was factored in.
Sorry, is this 506 you've moved to?
Sorry, no, it's going back to 504. So the salary, the take-home pay is set out at 505. That's the amount that is taken into consideration in determining the overall amount of universal credit that will ultimately be paid. So that's how the system takes into account your wage in a given month or a given assessment period and applies a taper so as to work out ultimately the amount of universal credit that you would be entitled to. So, my lords, if you, and my lady, if you look then, if we do the same exercise with page 507, you see in respect of this witness that her earnings reported in the next month were higher. So we get that at page 507. So she earned a little bit more. In
So
that
the statement starts at 506?
Yes.
Yeah. Okay.
That extra amount is obviously taken into account in arriving again at the amount of universal credit that she'll be paid. And you can see there that it's a bit less, although all other payments remain the same.
Could I just ask about the advances that are mentioned on these pages?
Yes.
Just
that-
the last item in the deductions.
Yes, so that's because some individuals can ask for payments in advance of being awarded universal credit, and then it's taken off what you owe going forward. That's different from getting money from the Flexible Support Fund, but we'll come to that because you don't
Flexible
pay that
Support
back.
Fund is a non-recoupable
Exactly.
payment. Yeah.
But if you ask for an advance, it's a bit like asking for an advance on your wages, then you're paying that back over time. So, my lords, one can see by reference to these statements that the amount of childcare being reimbursed every month stays static. The overall payment flexes according to what's being earned in a given month. Now, this is a witness who had a child in a nursery school, so had high childcare costs, and we can see.
Sorry, you say childcare is static. I mean, that it is static in this particular case
It's
because he's
static,
being paid the maximum. It's not inherently static.
No, that's precisely our point, my lord, and that's obviously what I'll develop in this. This whole system was intended to meet the needs of people who work flexibly, and we'll look at that when we look at all of the materials about the development of universal credit. But that's precisely the point. In a given month, you may work more hours, you may work less. You may be able to depend on a parent to help with childcare. You may need to use an after-school club. The whole system is based on being able to flex according to need, but also fundamentally, the ultimate amount of universal credit that is paid at the end of the assessment period has to factor in the amount that you ultimately earn at the end of the month and is then tapered. And that's why Miss Parker describes in her evidence that it's not just a case of being able to separate out bits of universal credit like childcare. It has to be factored into this overall calculation. And
Well, I see that, but I mean that's obvious. But what particular point do we get out of that?
well, again, my lord, I think the point that's really important is about the flexibility of this scheme and its ability to meet the needs of people who earn more in some months and earn less in others. And as this case demonstrates, if you earn an amount at the end of an assessment period that's over universal credit, well, you're not going to get a universal credit payment. That obviously follows. So there are obviously complications involved in paying on the basis of a liability, which may or may not ever be realised. But my lord, I hope that I can develop that, because that's an important part of our submission as I go forward. And my lord, just to say on this, as regards this particular witness, she also demonstrates that for people that have that kind of childcare predicated on child being in nursery week in, week out, that as regards those sorts of recipients of universal credit, their payments then reduce in holiday periods when they're off work and looking after their child, because obviously the child's not in nursery. And if reference is needed to that, you can see it at pages 516 and 518. So my lord, again, just coming back to the fundamental scheme of this, what it demonstrates is that universal credit, and as Ms. Parker says in her witness statement, it's not an indemnity against every need. As regards those who are working, it is bolstering a working income in precisely the same way that the individual is being paid their salary. My lord, any suggestion that the 2012 Act was intended or could be distilled into just one overarching aim of making work pay is apt to misrepresent. The 2012 Act and the associated regulations revolutionised the entire system for the payment of benefits in this country, and consistent with that, it sought to remedy a number of mischiefs and give effect to a number of statutory aims. That there were a number of policy imperatives behind the 2012 Act is plain from the white paper, Universal Credit Welfare That Works. And my lord, I wanted to take you to that just to set out how important some of the factors that are important in this claim were to the overall policy development. My lords, we get that again at bundle B2.
B2.
B2, page 699.
Yeah. So I'm just so it doesn't confuse me. Why did you say B2? Mine's just called B699.
Sorry, the page numbers for some reason have B at the bottom.
Yes, but they don't have a 2. You said B2
I'm
699.
so sorry, it's because in my notes I've written bundle 2.
Oh, I see. It couldn't matter less. It's just I want to make sure I stay to the right place. Yep. Okay. I am at the right place.
So, my lords, the aims of the Act are almost encapsulated in the very first paragraph on page 703, introducing the aims. The government intended to make the overall benefit system fairer, more affordable, better able to tackle poverty, worklessness, and welfare dependency. And what the government meant by fairer in that context was fairer, or fairness, incorporating fairness to those who funded the scheme for welfare as well. And that's why, as part of this overall scheme, the government also brought in or introduced the concept of a benefit cap as well. We don't need to go to that, but it's at chapter 2, page 707. My lords, we can see, my lady, from paragraph 10 of that introductory section as well, that another important aim of this legislation, or the scheme that was to be enacted, was to remove barriers to small amounts of work. And again, we see that at paragraph 16, that by allowing recipients to benefit financially from doing small amounts of irregular work, universal credit would reduce the incentive for people to commit fraud by failing to declare their work. And one sees as well that one of the ways in which fraud would be met was by having an automated system. My lords, that flexibility that the new scheme was intended to engender is also set out throughout this white paper. Again, we see it at page 709 at paragraph 15. The current system incentivises many people to work no more or less than the minimum hours required to qualify for working tax credit. This fails to reflect the flexible working pattern that modern employers and individuals need. The white paper also demonstrated the extent to which simplification was also a core aim, complexity being seen as a barrier to work. And we can see that again at page 710 at paragraph 17. And there are entire sections on simplification. I simply just want to draw your attention to the different places where they're set out. And over the page at page 711, the white paper set out the administrative cost of complexity. And my lords, one can see at paragraph 23 that it was estimated at that point that £5.2 billion a year was wrongly paid out as a result of fraud and error. 2.1 billion of fraud and error in tax credits, and 3.1 billion in work and pension benefits. And of course it makes the point too that underpayments are also a problem primarily to those who receive them. And I'll come back to this, but you'll see, as Ms. Parker sets out, that fraud and error in respect of childcare payments was a particular problem under the legacy scheme as well. Childcare was given its own distinct consideration in the white paper as well, at page 722. And we can pick that up at paragraph 42. The government recognised that people find the current childcare element confusing. The need to calculate average awards can be particularly complicated. Covering only a proportion of costs and paying it as part of an overall benefit can cause uncertainty. The new system provides an opportunity to improve and simplify the way support is offered, but we need to ensure that it remains fair, affordable and targeted. And one can see over the page that the government was going to take into account the pilots that were working on better ways to pay childcare, and I'll come back to those. And then set out that there could be better options for paying childcare, including through a voucher or discount scheme, or paying it as an additional earnings disregard in universal credit. And again, the white paper, as you'd expect, also set out the aim of encouraging personal responsibility by paying the benefit in a way that was akin to an earning, pointing out that 70% of all earnings, including those in the lower pay bracket, were paid in arrears. And that's at page 735 at paragraph 12. My lords, my lady, reducing fraud and error commanded an entire chapter of the white paper. That's at page 742. And it set out the reasons or the drivers for fraud and the link to simplification as well. Those are set out from A to D on that page, but they included the complexity and the fragmentation of the system, having means-tested rules that relied on people to report their circumstances, including their non-financial circumstances. And then at paragraph 5 of that page, that universal credit would drive down complexity and make it easier for staff and recipients to understand. My lords, my lady, that link was also made to savings at page 752, whereby it was estimated that simplification would amount to savings of £500 million a year. In terms of incentivising work, well, a central aim of universal credit was to remove the requirement to work a certain amount of hours. We see that at page 756. So that was linked, and we can see this from paragraph 19, to the withdrawal rate and eliminating the hours rules that was currently present in working tax credit. And that if you remove those, so in other words, if you remove the need to work a certain number of hours, 16 hours, then you would be able to create a much more flexible labour market. Workers would be able to work the number of hours that most suited their needs and those of their employer, without being constrained by the structure of the benefit system. Employers would find that their workforces became more flexible and open to opportunities for progression. And then at paragraph 20, it went on to discuss how that would be beneficial to a lone parent, how under the current system under working tax credits, they were effectively penalised by working any more than that legacy scheme allowed for, and how they would be able to benefit by working a smaller number of hours under universal credit. So that's why the conclusion was drawn at paragraph 22. Universal credit will match much more closely the structure of today's labour market, where part-time jobs and flexible working are much more common than they once were. This reform will increase viable jobs in the economy. And one can see that some of the evidence for that proposition at footnote 29, in terms of the increase in the employment rate, was driven primarily by part-time working. And again, just turning to the incentives to work, one can see at paragraph 25, by enabling people to work low or flexible numbers of hours and allowing them to keep more of what they earned, that would introduce a genuinely progressive participation tax rate. And again, my lords, picking that up at page 760, at paragraph 39, the paper set out that the majority of the reduction in workless households will be brought about by the increase in the number of currently workless people who will choose to engage in part-time work. My lord, that theme that flexibility would be of benefit to women and to single parents was also picked up in the equality assessments as well. My lords, we have those in the supplementary bundle 3. And that's at page...
Hang on 1 second.
So
Yeah,
the-
sorry, where are we going?
These are the equality impact assessments.
For which page?
So we have those they start at page 1197. So that's the equality assessment that went with the welfare reform bill. And we can pick it up at D1212.
Sorry, just wait while I get there. Does your bundle have tab numbers?
It does. So it's
Yeah,
tab 10.
useful to have those. Yeah. Okay. I've got it now.
Paragraph 51. So this is picking up on how universal credit would impact on incentives to work. And it states that help with
So
childcare.
sorry, just wait till I get there. Which paragraph?
Paragraph 51.
Yes.
So
Thank you.
setting out that childcare costs would be available to all lone parents and couples where both are in work, regardless of the number of hours that they work. Removing the current requirement to work 16 hours before any help is provided will provide an important financial incentive to lone parents and second earners taking their first steps into work. And again, over the page, referring to the change that would be made to take away the 16-hour requirement, that it would mean childcare support would be available to around 80,000 more households.
What point are you making by showing us all these particular passages?
Well, my lords, I want to demonstrate that flexibility, removing the 16-hour requirement, so as to be able to encourage flexible work.
I understand that, but that's not what this case is about, is it?
Well, my lord, it's an important, when one comes to judging the justification for the rule and the importance of preventing error and fraud, understanding that enabling flexibility in the workforce was one of the considerations to reducing the 16 hours.
But
Is an
this isn't
important-
about the reduction. The reduction in the 16 hours isn't the issue, is it, in this case?
My lords, it's an important consideration in this case because the reduction of 16 hours meant, and as one can see, that it was intended to encourage flexibility. It was encouraged...
If your only point you're showing us is that flexibility is fundamental, I don't think that's in dispute. I'm not trying to stop you showing us anything, but I'm just don't want us to be given lots and lots of examples of flexibility in areas which aren't the areas we're concerned with here.
Well, we are concerned with them here because if you are taking away the 16-hour requirement for childcare because you want to encourage people to take up any work that they can,
Yeah.
you want them to be able to work 5 hours one week
Yeah.
or every day the next week, or you want them to be able to work full-time at Christmas but not necessarily thereafter. If you want to encourage that kind of flexibility, that means that people are going to have childcare costs that vary. The system had to be able to take that into account. And that's why considerations go into how do we make this system work so that it doesn't encourage error or fraud becomes all the more important.
Okay.
And my lord, you'll see when we come to the development of the policy why that mattered. Now, my lord, I don't know if the reason that isn't clear is because the judgment discussed childcare being paid on a liability as though that all childcare is paid on a contractual liability basis. And what I will go on to show you in the course of these submissions, of course, that the provision of childcare is diverse. It is not all provided on that basis. And what the government ultimately wanted to achieve was to ensure that it was only paying parents for what was actually spent on childcare. And the fundamental difference is paying someone on a liability, so paying someone on the basis that they say, I owe this, I will pay this in the future, does not demonstrate ultimately that that is what they have paid.
Well, that's a different point. That's a point about... Ms. Dobbin, I'm sorry, I'm naturally impatient. I must try and stop myself being impatient, but we've been going for an hour with some very general stuff. Ultimately, the issues in this case are quite focused. Quite understand why you want us to to understand the background, but every now and then I just need to see where it's going.
Yes. Well,
but I will keep quiet. I trust you. I mean, I see this has been listed slightly to my surprise for 2.5 days.
Yes.
It was only 2 days before. I would certainly hope that you would be able to finish your submissions today, and that Mr. Butler better finish his with a bit of time for reply tomorrow.
We've discussed that, and
Yes.
that's certainly what we're aiming for.
Good. Okay. Well, look, the more I talk, the less likely you are to achieve it. So.
Well, I know that you're impatient, so I will.
Well, I know I'm impatient, Mr. Dobbins, so I'm trying to restrain myself.
Anyway, my lord, I think that you have the point, and if I
Yes.
can just give you the references, I won't take them. I won't take you to them, but you can see from page 1218, for example, paragraph 66, the new system was expected to be particularly beneficial to lone parents because of the removal of the 16-hour rule, and it cited research that most lone parents looking for work wanted to fit this in with their schooling, and they were looking predominantly for that type of part-time work. And again, just so that you have a note of this, page 1241, again, the significance of being able to work for a lower number of hours was emphasised. We see that again at page 1255 and at 1275 as well. So, my lords, and I think in order to meet the point, the reason why I'm setting all of this out is because it's important to demonstrate that universal credit had a number of aims that it was trying to meet. As regards childcare, it was intended to confer simplicity, reward any amount of work done, and it particularly recognised that new models of flexible working had to be encompassed within this statutory scheme, and against this had to be balanced the aims of reducing fraud and error. And my lords, we say that seen in the context of a benefit that could be paid regardless of how many hours were worked, regardless of how low, and which was generous in that it sought to recompense 85% of childcare costs, so more than in the legacy scheme, and anticipated that it would be paid to more people, we say that the government was entitled to arrive at the scheme that it did to ensure accuracy and limit fraud. My lord, those were all of the considerations that were in the mind of ministers as the scheme for childcare was being developed. This is set out in the witness statement of Neve Parker, paragraph 57 onwards. Now, my lords, in this case, the High Court decided that it shouldn't apply a particularly wide area of judgment, said that at paragraph 172, for reasons including that there was no evidence that ministers considered whether payment should be on the basis of a contractual liability. Now, my lords, when it comes to the law, I'll make submissions to you that that's just wrong, that the law doesn't permit a court to take into account other alternatives that were potentially available, which may or may not have met the problem. But I think it's important for that point, and also when it comes to the Johnson part of this argument as well, that this court does understand the iterative process that ministers went through in order to arrive at this scheme, and that you see how ministers determined, first of all, as a policy election, that childcare should be paid for in universal credit, and then sought to reconcile this with all of the aims that are set out in the white paper. So, my Lord, I hope you will bear with me, because I think, given how important this was in the High Court's judgment, that it's important that this court sees the consideration that was given by ministers to this point and how it developed. My Lord, that's set out in Supplementary Bundle 2, and it starts at page 849. This was a submission the 6th of December, and this was to the Minister for Welfare Reform. And that set out the high-level thinking at that time about how childcare should be paid for. And you can see that there was an advisory group on childcare. One sees that at paragraph 3. And the suggestion is made to the Minister at 4 that he remains open to discussion about the best model for payment. And it sets out and essentially mirrors all of the aims of the white paper. So supporting people that worked fewer than 16 hours, improving simplicity, reducing fraud and error. My Lord, fraud and error was part of the consideration, you can see, from the very outset. And then one can see the calculation options that were set out over the page. So consideration given to a disregard or an additional amount. Another option was a disregard but at a fixed level. And then a third option was an addition that might mirror the current system, so working tax credit, although the hope was to make it more responsive to fluctuations in childcare costs by moving away from annual assessments to more regular ones. And then, my Lord, one can see factored into all of this is the cost of the system and whether or not the government would only ever be able to pay 70% of the costs at that time. And then they talked about there could be a set amount to all parents as well. And then there's a table, I won't go through all of it, which sets out the sort of pros and cons. And one can see that under the proposal, childcare element proportion of the concern was raised.
Which page are we on?
I'm so sorry, over the page, at page 851.
Yes, sorry. Yes, I've got the penultimate column.
Exactly. So
Yep.
One can see throughout this table that there's that sort of discussion, the broad options, the strengths and weaknesses of each one. My Lord, we then pick up the thread at page 856. And again, this is addressed to the Minister. And to the various other interested persons. And it was a readout from the expert advisory panel on childcare from the day before. And one can see that there was broad agreement on key points. Childcare costs needed to be funded to the right level. They supported the privileging of formal registered childcare. Childcare support should relate to actual childcare costs, not averages or fixed amounts. There's reference to the fact that there was conflict between what parent needed, flexible childcare to fit in around unpredictable working hours and school holidays, and what providers need, regular, predictable demand. And we can see there support from CAB about having a system that was a good deal more simple. My lord, over the page, at page 857, two of the stakeholder groups did not support the idea of payments going direct to childcare providers. They thought that this group would create unmanageable complexity for parents because they're using multiple providers and having to top up the government contribution and was too great a burden. My lord, again, if we move on to page 859, and again at paragraph 2, reference to the aims of the white paper about simplification of support, extending it to those working less than 16 hours. And you can see from paragraph 3 that this wasn't just being dealt with within the Department of Work and Pensions. It also took in input from the Treasury, Revenue and Customs, and the Department for Education as well. And what was being raised here was whether or not the Minister was interested or thought that provision should be made for a voucher scheme. And then if you go over the page to page 860, you get a clear sense of the importance of fraud and error in terms of the scheme that would be arrived at. So again, the reference to support to those working under 6 hours and simplifying. And as regards the legacy system, fraud and error is currently at 25% of total childcare expenditure.
So where are you reading from?
I'm so sorry, that's paragraph 9A and B of page
Oh, yes.
860.
Thank you. Got it.
And underneath that were the key design objectives, again reflecting those that were set out in the white paper. And then this suggestion made to the Minister is that support should be incorporated into universal credit and its taper to make sure that it was going toward low-earning families.
Where do we get that?
At paragraph 11.
Sorry, I've been reading on. Thank you.
And again, my lord, there's further discussions of the model that could take. And they're effectively setting out the reasons why it wouldn't have achieved the aims to have a disregard. And then at 15 onwards, the discussion about reproducing CCE as it currently stands, but wanting to extend it to those working fewer than 16 hours. And then again, we say at paragraph 16 concerns about it being set at 70%. So, my lords, if we go over the page to page 862, it set out the 3 alternative approaches. So, paying childcare based on actual costs reported each month, easier to calculate but would require greater contact, a flat rate or a fixed rate award. And then one can see this would be based on a snapshot of costs in the weeks before claim or an estimate of costs for the first month of work, and then paid at a fixed rate. And then again at 20, consideration of who should we pay this to, who could we pay it to. So raising whether or not it should be payment to the parent or third-party payment direct to providers. But again, pointing out how does that work if you've got more than one provider. Payment by voucher raising the point there that they would have to do further work on the costs and practicality of that, because it would depend on IT, not currently in the high-level design. But again, pointing out there would still be a disadvantage because parents would still have to pay some directly. And again, asking the Minister, if you're attracted to vouchers, we need to know that so that we could take that forward. And then saying at 21 we'll be exploring the practicality of the different options, and reference there to taking account of evidence collected from the recent pilots. My Lords, if you go back in the papers, there is a further submission to ministers as well. In the February.
Which page?
825. For some reason it's out of chronological order. Again, this paper is concerned with the fact that they anticipated increased uptake in the benefit, and they were recommending to the Minister that at the second reading support for childcare would be provided by an additional element, that it would operate on a percentage of costs to an upper limit, with support concentrated on the UC objective of reducing workless families, that it was still under discussion at what level it would be paid at, that payment would be available to all parents in employment with formal childcare costs not restricted to particular subgroups, and that you're considering ways of streamlining calculation and awards to minimise errors and increase effectiveness. And then 5 sets out that it was preferred that the government would be able to pay more childcare costs out, so they wanted to increase the amount available, but then setting out at 6 how much they thought that would cost, so £700 million beyond the existing funding envelope. And again, when they were setting out the high-level considerations in play, one can see that they were still considering, we get this at 10 onwards, restricting support to lone parents only. And one can see at 13 that was ruled out because it was known from evidence, so we know from recent yet to be published evidence on lone parents, that the hours of childcare provided by an ex-partner far exceeded those than for other types of childcare. So I think making the point that when it came to lone parents, that the non-resident parent was also a source of childcare to them as well. So a reason not to target it on that basis.
Why is that material?
Well, my lords, I think it just...
I understand the point, but I just understand why it's not anything to do with what we got to decide.
Because the conception might be that lone parents are in a particularly disadvantaged
But no, is anyone suggesting that in this case?
Position when it comes to childcare, and that may not inexorably be the case as regards every family. Well, my lords, it may be when we come to considering indirect discrimination and come to considering whether or not parents in this particular group are disadvantaged compared to others. Now here the comparison was said to be between men and women. But the idea that single parents necessarily may have recourse to formal childcare that other people don't may not necessarily be the position in all cases. And my lords, just to finish off on that, at paragraph 27, the submission refers to the fact that there were ongoing meetings with stakeholders where we've explored these approaches, and again working with officials from the Treasury, Revenue and Customs and the Department of Education as well. And then it's set out, and I won't go through all of this, but it set out the implications that this might have on the different groups of people who were taking up working tax credit. And it also set out at page 833 the knock-on impact or the related policies that this also related to. And as one can see set out there, and it's a point I'll come back to because it is important, that there was already free childcare.
So sorry, where are we on page 833?
833, other factors and policies
Yes, I see. Yeah.
that will impact on childcare take-up. So as regards those children for whom childcare is particularly expensive, so those children who are not yet at school, that there's the free offer of childcare for 2-year-olds, that's up to 15 hours. But for all 3 and 4-year-olds, I think this encompasses nearly all 3 and 4-year-olds, there's a free childcare offer of 30 hours. And my lords, I'll come back to that because that's obviously an important part of the consideration in this case as well, that there is, as an adjunct to universal credit, already a very generous provision made in respect of children who require the most expensive form of childcare. My lords, my lady, the pilot study is at page 809. So there was a pilot study based on paying out on a system of actual costs. So page 809 is the report, and this is also referred to in the statement of Miss Parker. And it just introduces that at the first page. In addition, evidence from HMRC Childcare Affordability Pilot, actual costs pilot, has been...
Sorry, where are you reading from?
It's the first paragraph.
Mine's this paper sets out, where's the
So
phrase?
I've just moved, I've skipped.
Okay,
to
okay,
the bit that
sorry,
actually
yeah, no,
matters.
got it now, yeah.
So this paper explored the extent of fraud and error in the legacy scheme, and it also took into account the pilot of actual costs that had also been run and which you've already seen reference to in the briefings to ministers. And it's described at footnote 1, the actual costs pilot tested the impact of a different system of reporting and payment of the CCE, but where the total level of support was the same as the current system. The alternative system involved reporting childcare costs every 4 weeks and receiving CC payment in arrears, in contrast to weekly or monthly payments that those on the standard system of CCE received. And my lord, one sees at page 810, fraud and error statistics related to the legacy scheme. And that's the paragraph under the table. And again, one sees the figure there, a quarter of monies paid out in childcare is paid wrongly in fraud or error. And then the report goes on to refer to the pilot at page 820. That's the last section of that page. And one can see, I won't read out all of this, but the third paragraph down, for those that experience changes in their childcare costs, the 4-weekly system was seen to be particularly helpful as it better reflected the cost.
Sorry, we said is that the 3 paragraphs down, did you say?
Yes.
The majority of participants on the pilot scheme felt that they understood. We're on page 820.
Sorry, I had read over the page.
Don't worry, no, just tell me where I'm meant to be looking at.
So it's the 3rd paragraph down.
Some of these participants said.
That they would find it more
Yep,
convenient.
okay, thank you. No, I got it.
And then for those that experience changes in their childcare costs, the 4-weekly system was seen to be particularly helpful as it better reflected the costs they incurred at a given time. Only a small number of the pilot participants stated that they found it difficult dealing with payment in arrears.
Can I just understand the reporting system? Is it a once-only report during the 4-week period, or can it be reported?
In this test pilot scheme, yes.
But under the scheme as it developed, it's a rolling programme, is it? Or can it only be done on one occasion?
I think so. Under the current system, in the assessment period, you would report what you paid. So if you paid an after-school club a couple of times throughout that assessment period,
Report when paid.
you would report what you had paid during that period. So you might show the receipt for what you paid. In some instances, you might be asked for your bank, to demonstrate that through your bank details. So that's the essential way.
So, sorry to digress, because I know you're keen to show us this material, but if it was done on a liability basis, and the invoice came in at the end, or towards the end of the assessment period, and was then reported with the payment due within 7 days, the payment would have to be made before the benefit was received anyway.
Yes, so if I understand what you're suggesting, if a childcare provider wanted you to pay upfront costs and gave you an invoice so that you paid them, I think what you're suggesting is if that fitted within an assessment period and you reported them and then repaid them within the 7-day period, I think what you're saying is, could that work?
Well, I think let's take a concrete example. Suppose the system was based on liability. Invoice, deliver the invoice, and then you will be paid when payment is due as an element of the universal credit. That payment would be, I think, 7 days after the end of the assessment period.
Yes.
Whatever the period is, anyway. If the invoice says our terms are payment within 7 days, then so long as the invoice was delivered more than 7 days before at the end of the assessment period, the individual would have to pay even so, even if it was an invoice-based system rather than a receipt.
Well, we'll obviously come to the reality of that, because we can see that even in the claimant's case here, although it appeared that she had to pay at the start of a period, in fact she was allowed to pay it in tranches. So even if someone gets an invoice, query whether or not that's actually how they would pay. But our point about all of this is, if you tell me that you're going to pay something in the future and I pay you that, I ultimately don't know whether you've used that money to pay your childcare or not. And there doesn't seem to be any suggestion here that childcare providers just say, well, sorry, that's it, your child's not coming. I mean, there's obviously give and take. The system works on a more casual pay-as-you-go basis as well, as we see in other examples.
But there's no real evidence about how, if there is, I haven't seen it, about how childcare providers expect to be paid. On a purely anecdotal basis, I would have thought some of the more informal childcare arrangements, they'd expect cash there and then. You might say, I need an invoice in order to claim universal credit, and you get given it, but you expect to be paid before you leave, before you pick up your child. I thought that was quite a common arrangement.
Well, my lord, we see here, for example, and it's referred to in one of the ministerial briefings, that, for example, the use of childcare after-school clubs, now obviously some of them might ask you to pay in advance, but we see whenever we look at the detail of the sorts of examples that were used by the stakeholder groups, that there were people who were getting childcare on an ad hoc basis as well. So their childcare needs were changing from week to week. And in fact, that was one of the submissions that was made to the select committee in this. We'll come to this, whereby one of the stakeholders says in terms, one of the problems with childcare is it fluctuates wildly, that's the words they use, from week to week, month to month. And in my submission,
This is all a different point, isn't it? This is fluctuation in child. We're talking about the difference, and my lord's question was about what difference it makes if it's a liability payment or a receipt payment.
But
The point I think both of us are making in slightly different ways is, which may actually be a point in your favour, that by having it on a liability basis, you don't necessarily avoid the problem that you have got anyway. The point which Mr. Butler is challenging, because even on a liability basis, the liability may be to pay now,
yes,
and you don't get paid till later. You don't get your benefit till later.
My lord, it is a point in our favour, and
Well,
it's not a
exactly.
skeleton argument for that reason, but there are a number of different ways in which it's in our favour. First of all, we say this idea that everyone pays their childcare on a liability basis at the start of a month in that neat way is not borne out by the evidence. The evidence suggests that there are many different ways in which you pay. So the first question is, how do you pay on a liability basis if in fact your childcare changes over the course of an assessment period? And the point on behalf of the Minister is the fundamental difference between paying you on the basis of you already having paid is that the Minister knows that that is what the money has been used for and is recompensing that. If you pay on a liability basis, you don't know if the money will be applied for childcare or whether or not the individual may, because they face all sorts of difficult circumstances, use it for other things. So that's the first point. But the second point, my lord, is that we agree, and it's part of our submission, and indeed the High Court recognised this, that even if you did pay on the basis of a liability, that still involves a necessary weight, and it would all depend on where in your assessment period.
Yeah. Well, okay, I think
That-
as you can
that
tell, we've got
invoice.
that point.
Yeah.
I'm sorry, this is, I'm afraid, what happens if you start going very carefully through the evidence. Judges can't help anticipating your submissions, but we'll try not to. But I think the problem will be solved if we get sooner to your submissions.
But my lord, and I'm going to go further, because this also goes to why we say the judge is wrong in law. The judge here wasn't saying, well, there's a really obvious
But
alternative.
Mr. Can I not, sorry, but I don't think what's terribly helpful, and it's partly our fault because we asked you a question. When we get, what's most helpful is to get to the judge's judgment, which we obviously all read, but you're presumably going to take us through and point out the flaw, rather than anticipate it now. You'll say, well, you asked me, so why can't I? But I think we'll get lost if we start anticipating your submissions. But the message is the sooner we get to them, the better.
Well, look, my lord, the reason why I'm going through this, and ordinarily, perhaps in an appeal, one wouldn't go through this material in so much detail, but the reason why I'm doing it here is because this, in the High Court and in the High Court's judgment, this essentially, this process, this iterative process, was essentially set to one side. And the judge said, well, you didn't consider this specific alternative, therefore that's going to weigh heavily in the balance so that I reduce.
We
the
trust you, Mr.
discretion.
Robert. You go on doing it, and we'll wait.
Right, my lords, I'm nearly at the end of this, and
Good,
I think
okay.
we're probably coming to the point that ultimately is important here. My lord, if the next briefing or submission to ministers was at page 875. Sorry, my lord, if I missed this at page 869. Sorry, this predated the cost pilot, and if I did miss it, I apologise. But the submission to ministers said in terms, basing the award in UC on actual costs, either reported each month or whenever costs change, would be much simpler. This approach has received support in the HM Treasury consultation and broader evidence on low-income families, and is now being tested in the pilot. So that's where the pilot links in with the submission to ministers. And then the next submission after the pilot was at page 875. And again, if one goes over the page to 876, it was accepted that the voucher system could reduce fraud. We see that at paragraph 7. Again at paragraph 8, reference to 30% of childcare costs being overpaid. And then at page 877, the advice was that error and fraud could nonetheless be met through universal credit without having to go to vouchers for basing entitlements on actual costs reported, not asking for them annually, ensuring that the monthly statement showed the childcare costs that had been reported, using automated rules, and then at 11, separating out a proportion of the UC award as a direct contradiction to the stated intention to pay UC as a single amount to the household. It would introduce complexity because the amount they need to top up could change every month. And then at 13, reference to the cost of having a voucher system. And also over the page as regards that there would have to be a potentially complex set of exception processes. And then there's an estimated cost for that on top of the IT costs. And then again, the point is made that vouchers were vigorously supported by the nursery and childcare industry. However, and this is at the very end of paragraph 15, however, user organisations including Gingerbread, Family Action and the Daycare Trust are very opposed, preferring the principle of paying families directly. My lords, there was a workshop, my lady, for ministers on childcare, and we can pick that up at page 811. And the delivery design proposal was set out to ministers. And we can see the fourth paragraph down. It was agreed that claimants will be able to claim for deposits, upfront fees, advance costs, that you could claim childcare costs before you started your work. That's called the run-on. And then claimants will be asked to report childcare costs that they have paid out during the UC assessment period, that you'll report your costs online monthly, that they will be linked to cash paid, and then making the point that it mightn't specifically relate to the assessment period. And then at page 822, ministers were broadly in agreement with the above proposal, but they had concerns about the rule base and wanted to know that it was robust enough to prevent someone who's working 5 hours claiming for 25 hours of childcare costs. And one can see there that there was going to be a workshop for stakeholders on the same point. And my lord, one can see then what was conveyed to stakeholders at 844 onwards. And again, just for your note, at 886, the reference to reducing fraud and error again. Page 888, claimants report that they have paid out childcare during that assessment period. Report costs monthly. And then at 889, again setting out that this was part of the overall global support for childcare, which encompassed the 30 free hours, the 15 hours for 2-year-olds as well. My Lord, the readout from that meeting was also set out and recorded at page 891. So these were the questions that were asked. Will parents, so sorry, if you look down to CPAG, will parents go to the UC system to pay upfront costs? We're looking at this, there'll be some upfront loans in UC more generally. And then why doing cash rather than invoiced? We need to fit in with everyone's billing types and we don't want to have to do any reconciliation. My Lord, in my submission, that's an obvious and important point, that the government would not be able to just pay on the basis of an invoice. It would have to reconcile whether or not that amount had actually been used for the purposes of childcare. And my lords, again, that was conveyed to ministers. We have that at page 895. And again, can I just draw your attention to what it says at paragraph 3? We've had several meetings with stakeholders during the development of the policy, in addition to the ministerial seminar that you held in May. And then at 5, referring to the meeting we've just looked at, in general, the response to the delivery design was very positive. Stakeholders appear to like the simplicity of reporting paid costs, removing the need for estimates and complex calculations. They were pleased with the proposition of paying advanced costs and having a run-on. As expected, I draw your attention...
Just help me, what's paying advanced costs mean?
My Lord, I think that that probably is a reference to what was said about deposits. Because if we go on, what it goes on to say is, as expected, they did raise some concerns about childcare payments always being in arrears as part of the Universal Credit Award, and the timeline for some claimants being as long as 4 weeks. However, both provider and family representatives suggested that work could be done with providers to change payment and billing and offered to work with the department.
What would that mean in practice? Would that mean that they require payment only at the very end of the assessment period, so that you have to carry the debt for only 7 days? Is that? Well,
I think that that's probably all that it could mean, that childcare providers might be amenable if they knew lots of people are paid on this basis, that they might be amenable to moving or changing the way that
but that's what it would have to mean, wouldn't it? Because if it's genuinely in arrears on the basis of payment, not invoicing, that will never solve the problem, but you can mitigate the problem by them requiring payment only at the end of the assessment period.
Yes.
So that would have to be different for different clients, because everyone has a different assessment period.
Yes, and obviously that then would depend on that industry, and I think one can see from...
Well, it would, yes, it would depend on individual childcare providers.
Yes, but also yes, generally.
Because there's not much general coordination, I imagine. I suppose schools are the biggest ones.
Yes. But, I mean, what we can see, because all of these, well, not every childcare provider provides the government free hours, but the suggestion appears to be in the material from the nursery providers here that the free hours provision is generally paid in arrears. So they are paid in arrears, it would seem, for the free hours.
But the free hours, they're paid by the government, aren't they?
They are, but it seems, and that's just going by the evidence from one of the providers, that they get those costs. I think it actually comes through the local authority, and that those are paid in arrears.
Not quite sure how that.
Anyway.
That doesn't matter. You answered my question.
But my lord, the reason why I was drawing your attention to as expected, I mean, clearly ministers were aware that this might be an issue, and that's obviously the importance of that. And then over the page again, need to consider the difference between paying upfront costs and allowing a parent to put their child in childcare. So that's the run-on. So looking at this distinction and the cost and implications. And then it goes on, although stakeholders were pleased with our intention to allow parents to claim upfront childcare costs, they did raise a concern about the work incentive implications if families have to pay that initial amount out of their own money. So what they appear to be considering is that issue of having to pay upfront in addition to payment in arrears. Action to consider interaction with other support available to help parents with upfront costs, budgeting loans, which we've already seen in the statements here, and support via the flexible fund.
Sorry, I'm not quite understanding this. What does claim upfront childcare costs mean? But first, I think it means the opposite of claim childfront cares in arrears. What does upfront mean?
Well, I think what that must refer to is when parents are asked, for example, to pay a deposit, or if they're asked to pay in advance. So in other words, if you're asked to pay your month in advance. And
Oh, I see.
See here.
Got that, got it. Yes, I see.
So although obviously if you pay for your childcare in advance.
Now I understand. No, I got that.
Yeah.
Can I just go back to page 820? I just wanted to understand the nature of the document that we were looking at there. It's, this is the evidence on issues in the current system, which took into account the pilot project.
Yes.
But it doesn't show the addressee, and I'm not sure you told us what the evidence was about who saw this.
My lords, I think that the evidence really comes from the ministerial submissions. In other words, that the officials were party to and expecting these pilot results.
Yeah.
And were taking them into account.
Because I noticed, I'm not sure you read this passage, but on page 820, in the middle of the page, immediately after the passage you certainly did read, it says only a small number of pilot participants stated they found it difficult to deal with receiving payments in arrears.
Yes.
That seems to be one of the results of the pilot project.
Yes, my lord. I think I did.
Maybe you
thought
did.
I had read
Yeah.
it.
You did, yeah.
Yeah, I wasn't listening then. Sorry.
I won't take it personally.
I'm sure I was doing something else important.
Sorry, the answer to my lord's initial question, which I think was, and even if it wasn't, it's the one I now want to ask, is this document, this is a document at official level. It's not a document that was supplied to ministers. It may not matter, but just factually.
Well, my lord, I don't know. It may have been provided.
Well, I just wonder what the
to
evidence
ministers.
was about that.
I'm not sure that we know if.
Well, I was rather assumed that Ms. Parker, in her witness statement, would have described this document and said it's one of her exhibits.
She does. Yes, she certainly does, and she does refer.
Does she not
to
say
it.
who got it?
My lords, it was obviously a report or a pilot commissioned as part of the reforms.
No, I'm asking just a very factual question. In para something, Miss Brett does have witness statement. Does she say this exhibit NEP5 was supplied to ministers?
I'm not sure that she goes that
Or perhaps your
far.
junior will just.
Yes, I'm not
just-
sure that she is specific.
That's fine. Give us the answer later. That's fine.
But my lord, and we may come back to this. The fact that these
I
pilots-
don't get trapped into submissions as a purely factual question. I absolutely understand there's a whole issue about how much it matters whether a minister saw a particular document. But
Yes.
at the moment, I'm just interested in factually what this document is and who saw it.
So my lord, just following on from that, what all of this demonstrates, obviously, is that there was an iterative process. It discounted certain policy choices following consultation with departments across government, with stakeholders, and ultimately involved ministerial decision making. It demonstrates that ministers were concerned to arrive at a scheme which balanced out all of the policy imperatives in the white paper. Ministers obviously attached significance to the fact that stakeholders wanted the money to go to families directly, notwithstanding that vouchers would have provided a higher level of protection against fraud and error. It's plain from the outset that the model was going to be based on actual costs. It demonstrates that ministers were aware that specific issues had been raised about payment always being in arrears, and that the consideration or the solution to that was that additional support could be provided by other means, so through loans or through the flexible support scheme. It also demonstrates that it had been considered and thought about in terms of why invoices were not the answer. And as I've said in my submission, it's because it's obvious, and the answer is plain on the face of the papers, that it would involve reconciliation.
What does reconciliation mean in this context?
Well, my lord, in my submission it means checking what has been paid and whether or not it has in fact ultimately gone for the purposes it's been paid. Has it gone for childcare purposes?
Well, I haven't quite understood exactly what the point there is. If I'm an after-school club or a childminder and I invoice you, and you submit evidence of the invoice and receive your benefit, and then with luck, depending exactly on the timings, are in a position to pay the invoice by the time it falls due. What's the problem from government's point of view? The problem is you may not pay your.
You might use it because
you might use it to buy food, or
you might have other pressing needs that you need to meet before you pay your childcare.
But is that the end of the world? If then you've obviously got a problem with your childcare provider because they are not being paid when they should have been. But nobody suggests you didn't receive the service, which is what the government wants to ensure you do. There's no question of fraud in that situation.
Well, my lord, you'd still be getting the money for the childcare, and
Yes.
you wouldn't be paying for
Well,
childcare.
no, but you would gain the childcare and you're getting the money for it. If through fecklessness, that's a harsh word, but perhaps I should just say inability to manage, you get your finances in a muddle and you've spent it on something else by the time the childcare provider wants payment. Obviously, that's a problem. I'm not suggesting it isn't a problem, but it's not a problem of fraud or error. You've had the service, which the government is keen that you have, and you had the money to pay for it. If you've then got yourself into a mess, that's undesirable, obviously, but it's not contrary to government policy, is it?
Well, my lord, I think that it is, and I'm not sure that it could just be that you can say that that's not fraud, because I mean ultimately.
Well, it's obviously not fraud. Let's be clear about that. It's not fraud.
Or error. I mean, it means that the money is going towards an end that it's not supposed to go to. I mean, it should be paying for your childcare, and in that circumstance, you know, what if the person, I can't pay my childcare, so, you know, I'll get a parent to look after the child, or I'll get a friend to help me out for that week. It doesn't necessarily mean that the money would be ultimately used for childcare either. But I think the point, coming back to the systematic one, is that the government must be entitled to enact a system whereby it can be sure that it's paying out this money, it's paying it on a flexible basis, and ultimately it's confident that it's being paid.
Yes, don't get me wrong, I'm not making a bigger point that it doesn't matter. I'm just trying to see in what way it matters. It's not, it doesn't seem to me to be a fraud and error problem. It's a problem about inability to manage, which may then mean that people, maybe one obvious problem is the childcare provider won't go on providing the service because you owe them money.
Yes, that may be the...
Yeah, okay.
But our point is really the systematic one, that if you have a system that has to provide for all circumstances and all different types of childcare, diverse as it is in this country and numerous, that you need to have a system, and it was the aim of the Act, obviously, to have a system that provides as much as possible against fraud and error. And our submission is that recompensing people on the basis of what they have paid and what you know they have paid is the best way to achieve.
Yeah, I obviously get that point.
Either the working tax credit system was obviously different, but the scale of the fraud and error within it demonstrates, obviously, that there was a really significant problem that the government were aware of, and which was informing the subject matter experts who were ultimately deciding upon the scheme that should be arrived at when it came to childcare. And it really is striking the extent to which there was fraud in the legacy system and error as well.
Well, I've got all that, but I don't quite see how that relates to this particular point. But unless you're in to suggest that people are producing fraudulent invoices,
well, but that, I mean, the system obviously...
then you can produce fraudulent receipts. So.
You can, but if you have a system based on proof of pay, if you have a system that also enables you to check that a payment has gone through by way of a bank account, I accept that the system can't operate against fraudulent receipts, but that doesn't mean that a system based on invoices is any better or...
I wondered at one stage whether the perceived problem was that people would commission and then obtain invoices for childcare to be provided at some future stage, and then find that due to a change in circumstances they didn't actually use it, so that you would have got payment for childcare that was to be received during the assessment period but wasn't in fact received. We haven't seen anything of that kind in the papers that you've shown.
But that's, again, I think that comes back to the point, if you pay on a liability basis, and then, you know, you get your mother to look after a child or a friend, that's exactly what could happen.
That's a different example from
There's a liability. Problem with that is that there's a liability unless you can somehow cancel it.
Well, I think as well that suggests that there's that degree of formality around childcare as well, and childminders and nursery schools.
I mean, I can see the point that my lord makes, which is you can see the potential for getting money for something that you don't actually use it for. If you get a payment up front on the basis that you've booked a slot at the such and such nursery, and therefore, on the face of it, you are liable to pay the such and such nursery £10 a day or whatever it may be. And you then cancel that booking. There's nothing to check up on the cancellation of the booking because Grandma can walk down the road and look after little Jimmy. And once you've got all of that sorted out, then I can see that proof that you've actually paid the nursery eliminates that kind of problem.
Well, does it totally? Because suppose the arrangement with the nursery is we require 50% up front. I mean, you were referring to this yourself, deposits. I have no idea how many they are, but let's just take how much they are, but let's say 50%. That is a problem you have with a proof of payment. You've paid the money, but you've not ever actually had the service. But if it's a genuine non-returnable deposit, then I'm not sure it's fraud. It may all be perfectly genuine. But the government has ended up paying money it didn't need to have. So this is a problem that you would get. The problem about advance commitments isn't totally solved by saying, oh, well, we'll make it proof of payment rather than proof of liability. It's a problem you'll have anyway.
Well,
maybe greater, I suppose, if you have it on proof of liability.
My Lord, we'd say certainly greater, but I think, again, just coming back to the system, obviously knowing that this is what someone has paid for childcare means that it has been applied for that purpose, and you're simply reimbursing it. Deposits are different.
I hadn't appreciated till you took us through this that, although I'd thought about it, no doubt, that deposits were ever an issue. But it's clear they were. It's clear one of the things, and obviously stakeholders were pleased, because presumably this happens quite a lot in the market, people ask for money up front.
Yes.
And in principle, as I understand it, if you pay the money up front, then you get it back in your next...
No, I think a deposit would be treated differently because a deposit is just to hold a place as such. It's not actually for the provision of childcare. So I think deposits would be claimed by way of an advance or through the flexible support fund.
Okay.
So I think that one of the witnesses here may have had to pay a deposit, and she got that from the flexible support fund.
Yes, I see.
Rather
Well,
than
what about upfront payment? Deposit is actually a slightly loose term. Quite often, a form of deposit is, in fact, is then just set off against your liability if you actually take up the place. So, it's really a deposit may just be a form of upfront payment.
Yes, I agree with you. There can be that confusion. If you're actually just paying in advance, then that is what you can recoup because you're paying for childcare. So you can recoup that as part of your universal credit payment.
Yes, well, let's just stick with that and forget pure deposits. Let's just think about upfront payments, which are also referred to in these papers. You pay up front, then you don't use it for some perfectly innocent and genuine reason, but you've paid up front. Probably your terms with the childcare provider, they won't give it to you back. The government just takes that on the chin, do they?
Well, if you actually look at the regulations, it is for childcare provided during an assessment period. So it does actually seem to rest on childcare having been provided.
So what happens, though, if you perfectly genuinely claim for an upfront payment and the payment falls to be made in month 1, and the services were intended to be provided in month 2?
Child gets measles.
Whatever the reason, can you not 7 days? Can you not at the end of month 1 claim for the upfront payment?
You would have to, if you had paid
Yes,
and recorded those costs.
Yes.
You would have to let the government know that you hadn't in fact used the childcare.
But when? That you wouldn't know that till the follow. So in the meantime, 7 days after the end of month 1, you get paid for those upfront costs.
Yes.
Then a week later, when you actually were planning to take up the childcare, you don't, for whatever reason. You're saying you then had to put on your ledger, whatever the running, is it called a ledger? Anyway, you put on the vehicle by which you communicate with the sorry, I know I claimed £100 last month. Actually, we never used it. I'm telling you, what happens then?
Well, my lord, I think on the face of the regulations, you wouldn't have received childcare, so you wouldn't receive that.
Oh, I see.
So
You've already been paid it back on my lord's postulation. You've paid the deposit. You get paid it in the next assessment period, but in fact, the child falls ill and doesn't go to the play school for whatever period. So you declare that on the form. What then happens? Does it get credited back, or?
I might need to take instructions. on
Yes,
the
you were saying,
assessment.
yeah, I mean, you were saying, oh, well, you won't have paid it because the regulations don't, you won't have had anything for it because the regulations talk about childcare are provided. I thought the whole point about these papers, I really haven't looked at the regs, was that they did have a system for paying you for upfront payments, reimbursing you for upfront payments, if you like, or 85% of them. The truth is, this is probably not central, is it? You may all play into your hands, but it shows how complicated it all is.
Well, I think it does, and I think that it demonstrates all of the different circumstances that these regulations have to take into account whilst trying to create a system.
Well, what I
that's
suggest
simple.
is that we pause on this. I'm not sure at the end of the day it's going to matter ultimately, like a lot of what comes from the bench. But perhaps someone can just tell us at 5:00 when we come back after lunch, just briefly what the system is about upfront payments. We haven't seen the regs. We've only seen the discussion that in principle we're going to deal with it.
Yes.
Okay, now let's get back to where you wanted to be.
Well,
where are we going next?
So, my lord, just to finish off on all of that, I mean, the main difference, obviously, when we come down to it, is just that fundamental distinction then that you're recompensing what you know to have been paid and to have been directed towards childcare as opposed to a prospective cost. And my lords, then just turning to the law on the regulations, the fact that they are regulations aimed at giving practical effect to a high policy ideal doesn't give the court greater latitude to interfere with them. If authority is needed for that, it's the case of MA, tab 15, Lord Toulson at paragraph 34.
Let's have a look at that. Yeah. So what's the proposition for which you're citing this?
Paragraph 34.
Just to say in a sentence, what is the proposition which you're seeking to make good by
Well,
reference
the
to
fact
this?
that we're concerned with regulations as opposed to primary legislation
see.
doesn't make any difference.
So if I write it down, secondary legislation,
Yes.
well, it doesn't make any difference. It requires the same degree of, quotes, deference as primary legislation. Is that the
Yes.
submission? Okay. I know people don't like the word deference, but it's a useful
No, my lord,
shorthand.
I'll come back to that point again, specifically as regards the affirmative process for statutory instruments as well.
Okay, right. Well,
So-
that's the proposition. Which is the paragraph that shows that makes it good?
Paragraph 34, but I'll come to, it's the point in Bank Mellet as well about statutory.
Well, all right, but you were taking us to this authority. So
Yes,
do you want us to look at paragraph 34?
yes.
Right.
Sorry, I've already explained the proposition that it.
I know, but I want to see what paragraph 34 says. Yes, I see. So this is Lord Toulson endorsing what Lord Dyson has said in an earlier case.
Yes.
Which is the earlier case? Is it Steck? It's Humphreys.
Humphreys, yeah.
Okay.
Sorry, which tab are we in?
We are at tab 15, paragraph 34.
So
Sorry.
I'm not getting at you at all, Mr. Dockman. I was trying to understand it. This is really a proposition that we can get most clearly from Humphreys. Is that right?
Yes.
So
My Lord, I was just trying not to duplicate authority.
yeah, okay, fair
so
enough.
The fact that it was referred to there seemed to be a handy way.
No,
We've got quite a lot of
fine.
authorities.
No problem. I just so I understand. Yes, thank you. Okay.
I'm going to move directly on to indirect discrimination then, having introduced childcare by way of that backward material, and then I'm going to go to the judgment. and
Can I just get the
demonstrate
structure
all-
right? So, you're not doing a general exposition of the law at the moment. You're just picking up this particular point.
Well, my Lord, yes, because we've just finished with the regulations.
I understand. Okay.
And sometimes it's
No.
suggested.
I just didn't know how you were going. So and you say indirect discrimination are in there first, are you? Next.
That's what I was going to deal
Yes,
with because
okay.
it's ground one of the appeal.
Okay.
My Lord, the issue on ground one of this appeal is whether Regulation 31ZA unlawfully discriminates against men and women. The issue is not the hardship that might be experienced by some of those claiming it. That's an uncontroversial proposition. If authorities needed for SG tab 13 at paragraph 76, I don't ask you to turn it up now.
Just give me the reference again.
SG tab 13 paragraph 76.
And what's the proposition that you say is established by that?
Ultimately, what the court is concerned with is unlawful discrimination. The focus isn't on hardship that might be experienced by a group of people who are subject to the measure.
Okay, thank you.
The core proposition in order to demonstrate indirect discrimination is that it has to be shown that a neutrally formulated measure affects a disproportionate number of members of a group of persons sharing a characteristic alleged to be the ground of discrimination. My Lord, again, an uncontroversial proposition set out in SC in the Supreme Court at paragraph 53.
That's a very recent decision.
Precisely.
Yeah.
The analysis rests on demonstrating that the neutral measure produces differential treatment or differential effect on one group as compared to another. And my Lord, my Lady, the terms differential treatment and differential effect are used interchangeably throughout indirect discrimination cases. So the touchstone of indirect discrimination remains that it's a comparative exercise as between those groups affected by the neutral measure. My Lord, the paradigm European case on indirect discrimination is usually said to be the DH case. My Lords, I don't ask you to turn it up, but at paragraph 175 of that case, it's put this way: the court has accepted that a general policy or measure that has disproportionately prejudicial effects on a particular group may be considered discriminatory, notwithstanding that it's not aimed specifically at that group. And that's the analysis that is followed in all indirect discrimination cases. So, for example, again, to take the case of SG, and we can look at this, my Lords, if it would assist at paragraph 13. But again, I think it's an uncontroversial proposition. The European Court has accepted that a difference in treatment may be inferred from the effects of a measure which is neutral on its face. And again, discussed throughout that particular authority is the difference in treatment. And all of these cases, as I'll show you, rest on a robust evidential basis for saying that one group is disproportionately disadvantaged as compared to another. And we see that, of course, in SG. It was inevitable that the cap on benefits would prejudice women as compared to men. We pick that up at paragraphs 61 and 95. My lords, there are in the bundle some of the European cases on indirect discrimination that illuminate the sorts of circumstances in which it arises in the European context. And it might be quite fruitful to look at those, and in particular when it comes to weighty reasons and the role that weighty reasons has within the context of indirect discrimination as well. So the first authority that I was going to take you to, please, is Detritio, and it's in the second authorities bundle. Tab 35.
Yes.
I won't go through all of the factual background to this case, but it was to do with the assessment upon which disability payments were made in Switzerland. And one can see, if you pick it up at paragraph 48, the applicant alleged that she had been discriminated against, arguing that the combined method calculated the degree of disability and had resulted in her being refused disability benefit because of her part-time work. So it was a benefit that effectively didn't compensate you if you had worked part-time. And if we pick it up at paragraph 66, when it comes to the comparative exercise, and I won't go through all of the statistics that were referred to, that in the overwhelming majority of cases, the combined method concerns women who wish to reduce the amount of time that they spend in work following the birth of a child or children, obviously as compared to men. At paragraph 81, the well-known introduction to that paragraph that contracting states enjoy a margin of appreciation in assessing whether and to what extent differences in otherwise similar situations justify different treatment. And then at paragraph 82, the court reiterates that the advancement of gender equality is today a major goal in the member states, and that very weighty reasons would have to be put forward before such a difference of treatment could be regarded as compatible with the convention. And then we see there in particular references to traditions, general assumptions or prevailing social attitudes are insufficient justification. States are prevented from imposing traditions that derive from the man's primordial role and the woman's secondary role in the family. And then again, the well-known statement that a wide margin is usually allowed to the state when it comes to general measures of economic and social strategy. My lords, at 84, that if an applicant shows that there's a difference in treatment, it's for the respondent government to show that it can be justified. And again, a bit further down that paragraph, as far as allegations of indirect discrimination are concerned, the applicant must adduce evidence of disproportionately harmful effects on a particular group, giving rise to the presumption of indirect discrimination. In other words, disproportionate obviously demonstrating a comparative exercise. And at 85, as to whether statistics can constitute evidence, the court stated that statistics could not in themselves disclose a practice. However, in more recent cases on the question of discrimination, in which the applicants alleged a difference in the effects of a general measure of de facto situation, the court relied extensively on statistics produced by the parties in finding a difference in treatment between the two groups in similar situations, referring there, of course, to the DH case. And then hence in its decision in Hujajink cited above, the court found as follows, and then the reference in that case, where an applicant is able to show on the basis of undisputed official statistics the existence of a prima facie rule formulated in a neutral manner clearly, in fact, affects a clearly higher percentage of women than men. It's for the respondent government to show that that's because of objective factors. And then one can see the results of that analysis in Detrizio at paragraph 88. 97% of the people subject to the less favourable assessment were women. My lord, the same sort of analysis is applied in Hujajink at page 1128 of that bundle, tab 33. There aren't any paragraph numbers. The applicant complaint, this is a complaint, so it was about the withdrawal of a benefit. And again, if we pick up the legal analysis at page 1136, there was a statistical foundation for being able to say that women were disproportionately affected.
Sorry, whereabouts are you looking at?
It's the very first paragraph on page 1136.
The first full paragraph.
Yes.
The court recalls that Article 14.
Sorry, my lord, it's the very long paragraph that begins before. I was just picking up on the statistical analysis, but it starts at since Article 14 of the Convention.
Yes, I see. So you're picking up the statistics
page
at the top of the page.
Yes,
Yep,
exactly.
okay.
It's the whole.
Okay.
It's the whole of that.
Yep, thank you.
And again, the disproportionate effect as between men and women can also be traced through into the penultimate paragraph on that page.
Yep.
And then again, exactly the same point is made, that a specific rule formulated in a neutral manner clearly affects a higher percentage of women than men. It's for the government to show that it's a result of objective factors. So, my lord, the net effect of all of those authorities applied here is that when it came to the neutral measure, in other words, the payment of the childcare element, the respondent had to be able to point to those persons who were in an analogous position to her and demonstrate how she was disadvantaged on the basis of the same comparative exercise. Evident in all of those cases. We say it self-evidently does not permit an approach based on the fact that more women than men take up a benefit means that they are disproportionately disadvantaged by the measure. We say that the High Court was correct in this case insofar as it initially recognised that the correct approach was to ask who within the group of people entitled to the childcare element could the respondent compare herself to and demonstrate that she was disproportionately disadvantaged by comparison to. And my lord, that's evident if we look at the case of Delph, which is at tab.
As you say, this is common ground. This is how the judge directed himself, and Mr. Butler. There's no respondent's notice saying.
No.
Okay. Yep. You want to show us delve?
And it's all pretty trite because it's all set out in the most recent judgment of the Supreme Court in SC from paras 188 onwards. The correct approach.
Well, my lady, I agree that it is very well established, and it shouldn't be a controversial proposition that when you're looking at a neutral measure, you're ultimately looking at who that is applied to and looking on a comparative exercise at who's disadvantaged. But ultimately, that was not the approach that was applied in this case in the first instance, when the judge compared women getting childcare to women and men who were getting the housing element.
Yeah, well, speaking for myself, I can see where you're going with that.
Yes.
But it was a bit more appropriate to go for the second element, wasn't it?
And
You're comparing with single parents, men with who are claiming the childcare with women, then you're straight into SC territory.
Yes, and I'm going to come to that, but I obviously have to deal with the two parts of the analysis.
Of course, I think perhaps what we're hinting is that you're spending a lot of time on the bit that isn't in dispute before getting to the bit that is.
Okay, well, it's simply because,
Okay.
despite the clarity of the principles here, that wasn't the exercise that was conducted in the first part of the judge's analysis.
So you say the judge was actually wrong to use as a comparator all people who would be claiming universal credit, irrespective of what the elements were that were in it, with women who were claiming childcare element.
Yes, that's not indirect discrimination. Yes. My lords, I did want to take you to delve because I just want to deal with causation whilst we're in the authorities, so that I don't have to go back to it. Delve is at paragraph 28.
Do you mean tab 28?
Tab 28. And that's bundle 2.
Thank you.
My lords, I wanted to pick up at paragraph 26, and again, it's obviously a very well-known proposition that where a complaint relates to alleged discrimination in the welfare system, the court's concerned with the overall system as opposed to the individual circumstances of individuals. So I just want to pick that up whilst we're in delve, and then go to 71. And again, without going through the whole of 71, the court there stated, this is between D and E, indirect discrimination does not, instead it requires a causal link between the measure and the particular disadvantage suffered by the group and the individual.
I'm so sorry, where are you reading from?
This is paragraph 71.
Yes, but whereabouts?
D and D.
Between D and D.
Just above E.
Yes, I see, thank you. Referring to ESSEP.
And again at 72, the analysis in delve was based on a relevant comparator group. At 76, the claimants in that case advanced an argument based on J, D and A and the United Kingdom. And sought, one picks up at paragraph 77, that they sought to rely on the general point that they suffered a particularly prejudicial impact when compared to men because of the lack of a state pension. And then it goes on at 78 to describe that evidence. The court said at 79, stated in that way it becomes clear that a significant expansion of the law would result from such a broad application of J, D and A. It's undoubtedly the case that many groups have traditionally suffered in discrimination in the workplace, so that there are few opportunities for them. I won't read out all of that, but at the end that does not mean, however, that every measure that has that kind of prejudicial effect on a disadvantaged group in society amounts to unlawful discrimination, entitling that group to more favourable treatment unless the measure can be justified. And then at 81, it's a few lines down. It was going back to the court was going back to the divisional court's ruling. The divisional court were, we think, seeking to express in that paragraph that there is no sufficient causal link between the measure and the disadvantage suffered by women in this case. Even the broad test expressed in JD still states that indirect discrimination exists where a policy or a measure produces a particularly prejudicial impact on certain persons as a result of a protected ground, such as gender or disability. And then at 83, the ultimate conclusion in that case, that there was no sufficient causal link between the withdrawal of the pension and the disadvantage caused to that group. And my lords, for your note, but without taking you to it, see also the approach applied in the case of Adiatu, applying Barry and Midland Bank. That's a paragraph 149, tab 25, page 847. That a claimant can't.
Which paragraph? 149, did you say?
Paragraph 149. That a claimant can't rely on the absence of other financial resources not caused or related to the PCP. So that was an analysis under European Union law, but that was applied in motherhood plan at first instance in the indirect discrimination context, and that's at tab 30, page 1053, paragraph 62.
As you probably know, motherhood was heard on appeal in district court
Yes.
last week or
Yes.
a couple of weeks ago, but we don't yet have a decision.
No, but my lord, this case does raise a number of similar issues as
It
well.
does. I've just thought I'd.
Yes, and in particular, the argument about weighty reasons as well in the context of indirect discrimination and their interaction. And it's for that reason that, in fact, you should have a copy of the case of MA as well, raising the question of whether or not weighty reasons can ever have a role to play in
Fine. Well, you'll come back to that. Yeah. I was just drawing your attention to the fact that motherhood was pending. Yeah.
Which paragraph of motherhood were you directing?
Paragraph 62.
Us to, thank you.
My lord, drawing all of those principles together, it's my submission on behalf of the Minister that universal credit provided an uplift to the claimant's salary, paid in precisely the same way as a wage.
Hang on 1 second to take the state. Yeah.
And the inclusion of an element for childcare marked a progressive measure intended to assist her into work, paid in exactly the same way as her salary, and paid in exactly the same way as most of society. And this case brings into sharp focus the
Hang on 1
reason-
second. The inclusion of the childcare element was a progressive.
a progressive measure intended to assist women.
Using progressive in what sense?
Well,
You mean just good? It's just you're patting yourself on the
well,
back.
No, my lord, I mean in a way that was intended to help people to work,
Yeah.
to be distinguished and contrasted by the sort of measures that the European Court was considering, whereby...
Yes, I'm sorry.
People were
The progressive
penalised.
sometimes has a technical meaning in
Yes.
tax constantly. You weren't meaning that.
I didn't mean it like
Yes,
that,
okay.
I meant it as a...
Yeah, okay, thank you. Progressive measures to assist people, sorry, and I didn't get the rest of
Come
it.
to work.
inclusive of a childcare element, paid in the same way that a salary would be paid, in the same way that her salary was indeed paid, and in the same way that most of society is paid as well. And my lord, we say that that does bring into sharp focus in this case, on a much broader or a higher level, how the payment of childcare comes within the rubric of indirect discrimination. or to put it another way, if you took two people starting work at the same time, and say one just earned a bit more than someone else falling outside of universal credit, they both might be required to pay for nursery a month in advance. Both might have to find a way of making an upfront payment, and both would have to wait until they got their salary at the end of the month. And both would be in the position of paying for next month's fees.
Sorry, who are we comparing here?
Just to someone who might be paid a little bit more to take them outside of universal credit. So in other words, that the difficulties that people might face in paying for childcare can exist across the board. And I'll obviously come to the point of addressing.
This is really a causation point. It's about it's your point about the real cause of the problem is how much money you have.
Yes. But I think there is a real point here as well, though. If this benefit is being paid and is elevating the income of working people and is being paid in precisely the same way that your wage is paid, that there is a much broader issue about the comparison as well. And that effectively you're in the same position as many other people.
It's rather imprecise. What actually is the submission? You say there's a much broader point about. But what is the point?
The point is that you're being paid a benefit on a model that is the equivalent to the way that people in work.
I understand that. It's been something you've been saying all throughout the morning, which I understand. But what's the legal submission that is relevant to the question of indirect discrimination?
Well, I'm saying that it raises a fundamental and primary point as to how the payment of childcare can even come within the rubric of indirect discrimination at all if one looks at it at that higher level.
You wouldn't
before
look at it
one
at that
comes
higher
to.
level.
Yes, exactly. I don't understand what
You
the legal
don't look
submission
at
is. Vague phrase like it raises a fundamental question at a higher level. It's not very precise. What is your proposition?
Well, my lord, I'm not sure I can say the proposition again.
Well, you can, but then you won't satisfy me. It's up to you.
It is simply the point that if you take someone who's getting universal credit, they're being paid their salary, they're being paid their wage, they're getting their universal credit on top. And if the complaint is, as it appears to be the case in this claim, that people on universal credit are being expected to pay for their childcare.
Yeah, but I see.
That is something that applies.
But you're pushing an open door. No one's putting the case that way.
No.
The judge said he wouldn't put the case that way. No. You're saying he slipped back into doing it. That's fine.
Yes.
But then you can show that by looking at his reasoning. But I hadn't realised you're simply making again the point, which isn't really in dispute, that you can't simply complain that some people on universal credit find it difficult to find the money to pay up front.
Yes.
Speaking for myself, I absolutely see that. But the question is it discriminatory?
Yes.
And then we've got to find the groups
Yes.
compared with whom it is discriminatory. And that's really what this appeal is about, or this part of the appeal.
Yes.
Which I suspect you'll be getting to after lunch rather than before, unless you... but okay, I just wasn't sure what you were getting at, but now I see. But it's not really the main point, is it?
No, but what I would submit about the judgment is that it didn't take sufficient account of the fact, or didn't take into account sufficiently that overall raising up of an income, but to put the person in a position that was akin to that of everyone else in terms of how salaries are paid and how childcare is paid. So in other words, there isn't a particular disadvantage to those who get childcare through universal credit, because a person who's not getting universal credit might be in exactly the same position. And my lord's right then, we do say that the issue can't then be one of resources and who's got more money, because the courts have already said that that isn't a proper comparative basis for the purposes of discrimination.
Does it follow from that point that if you were to, as it were, correct the perceived disadvantage of the group who are within the universal credit parameters, you would create a discrimination against those who aren't?
Well, I think it would.
In other words, if you allow women who are claiming the CCE to get some relative advantage in terms of when they get reimbursed, as compared with people who are earning more than the level, would that be a discrimination? Is that your point?
Well, I think
Or an
it's
aspect
simply
of it.
the way that it's paid at the moment means that there's that the playing field as such is level, because that you might have to pay. You might have to pay your childcare costs on a liability basis. Obviously, affects different people. It's not just something that
Sorry,
affects
it's a completely sterile argument. When it's not appropriate to compare people who are earning enough to get them out of the universal credit system with people who don't. It's a completely wrong comparator. You can try and persuade us that that's what the judge did, although speaking for myself, I'll need a bit of persuasion on that. The real question in this case is, did he produce the right comparators? You've got a point on the wider element, which I think I understand, but I'm not sure that this particular point elevates your argument one step or another.
Well, I shall move it on.
Perfect timing. Okay. Well, we'll sit again at 2, and you're still reasonably confident you'll finish this afternoon with
Yes.
the expected level of judicial engagement, as long as it's not an extraordinary level. Right. 2 o'clock.
All right.